I lost over $25,000 to two predatory publishers who tried to copyright my book under their name, house my manuscript in their back office, and collect my royalties. Now, I happen to be an attorney, so I caught it and put a stop to it, but most authors wouldn't. That experience reminded me of something critical for you to know. The author who can document their work is the author who keeps it. The US Copyright Office expects authors to be able to document their human creative process. Not just say you wrote it, but be able to prove it with timestamps, with a trail that shows that a human made the creative decisions. Today, I'm showing you the 3-layer documentation system I now use with every author I work with. It's the same strategic framework we build into every publishing engagement at Made to Change the World Publishing. Because the best time to build your proof is before you ever need it. Now, stay to the end because layer 3 is the one that most authors skip, and it's the one that carries the most weight in a legal dispute. If we haven't met yet, I'm Ellie Shefi, attorney, strategist, and founder of Made to Change the World Publishing, a publishing house for mission-driven leaders like you. I'm a 12-time #1 international best-selling author with over 30 years of experience across law, business, education, and advocacy. My background is in intellectual property, and documenting human authorship is one of the most overlooked steps I see authors skip. Here's what's happening. AI can now generate content that reads like a human wrote it. And the line between AI-assisted and AI-generated is getting harder to draw. The Copyright Office knows this. In January 2025, they released guidance making it clear. If you want copyright protection, you need to show that a human made the creative choices. You may have heard of the Thaler case. Dr. Stephen Thaler tried to register a piece of visual art and listed his AI system as the author. The Copyright Office said nope, and the courts agreed. In March 2026, the Supreme Court declined to hear the case, so the law in its current form still stands. AI-generated work is not copyrightable. Now, that's the good news. Human authorship still matters. But here's the catch. Saying you wrote it isn't enough. When in doubt, the Copyright Office wants to see the work, your drafts, your revision, your creative process with documented timestamps that tell the story of how this book came together. That documentation is what separates the author who can defend their work from the one who's stuck just saying, trust me, I wrote it. And in the age of AI, trust me is not a legal position. It's not evidence. It's wishful thinking. In intellectual property disputes, the author with the paper trail tends to prevail. Documentation is critical. It's credibility, and you need to be the person who has it. So let me walk you through how to build that paper trail. Let's break this down into 3 layers. Layer 1 is your digital trail. That's the automatic timestamps your tools are already creating for you. Layer 2 are your human witnesses, the people who observed your writing process. Now, layer 3 is your public record. That's your copyright registration and your usage. Now, most authors already have some degree of protection with regard to layer 1 without realizing it, especially if they've been writing in the cloud. So let's start there. If you're writing in Microsoft Word or Google Docs, you already have evidence without even realizing it. Both Microsoft Word and Google Docs save your version history. Every edit you make is timestamped automatically. Every word you add, every paragraph you cut, every revision you make. The Copyright Office generally recognizes version history as evidence of authorship. So if you're not already writing in a platform that has built-in versioning, start today. Start documenting and building evidence. That's why every author at my best-selling book bootcamp opens a Google Doc, names it, and starts writing in it. That Google Doc is building the documentation they need. I've seen authors pull up their version history 2 years later and find hundreds of time-stamped edits they didn't even know existed. That's usable evidence. Version history shows intent. It shows iteration. It shows a human being making creative choices over time. That's your strongest piece of evidence in layer 1. And for thought leaders building a book around their expertise, that trail is everything. Now let's talk about the second piece of your digital trail, file metadata. Now every document you save carries a creation date and author name. Put your real name in the author field. When you save it, that name and timestamp travel with the document. And there's a third piece of your digital trail, cloud storage. Google Drive, Dropbox, OneDrive. Every time you upload or modify a file, your cloud provider logs the timestamp on their servers, not yours. You can't alter those logs, and neither can anyone else. That's powerful third-party evidence, so be sure to write in the cloud. Let the timestamps accumulate from day one. Those three pieces combine to make your first layer of proof. Now, your digital trail is strong, but files can be disputed and metadata can be questioned. But other people who watched you write, that's powerful corroboration that's harder to dispute. Here are 3 ways to build this layer of proof. First, email drafts to yourself. Every email creates a third-party time-stamped record that you don't control and can't alter after the fact. That's what makes it powerful. Make it a habit. Every major milestone, email the draft to yourself with a note. Here's my manuscript as of today. That's it. 1 line, takes a few seconds. But in a dispute, that email can be the thing that settles it. Second, use voice memos. Record yourself brainstorming, outlining, reading a draft out loud. Audio files also contain metadata, including creation dates. A time date stamped recording of you working through your ideas and processes in your voice is difficult to fabricate. Voice memos capture something no written document can. Your voice working through your own ideas in real time. Third, don't write in a silo. Anyone who observed your creative process can provide a statement. They saw your drafts at various stages. They watched you revise. They can confirm that the work evolved over time under your direction. They become part of your documentation. Now, in a copyright dispute, that testimony, along with the other records, can carry real weight. Now, before we get to the most important layer, I want to pause for a second. If you're realizing you haven't documented any of this yet, that's okay. That's exactly why I make these videos, so you can set this up before there's a problem, not after. If this is the kind of thing you want to stay ahead of, be sure to subscribe. Every week, I break down exactly what authors need to know about protecting and monetizing their work. The stuff most people don't hear about until it's already cost them something. All right, let's talk about layer 3. So let's talk about the official step of copywriting your work and building a public record. It's simpler than most people think. Now, copyright.gov is the official government site. The current filing fee is only $65 for the standard application. It takes about 15 to 20 minutes, and you just create the account, fill in the form, pay the fee, upload your manuscript, and the government will review your application. If it's approved, your work will officially be on record with the federal government. You generally don't need an attorney to file, although consulting one is always an option if you have questions about your specific situation. And here's something a lot of authors don't know. The copyright registration process now includes a question and certification regarding whether you used AI, to what extent, and for which parts. You are required to answer honestly. If you used AI to brainstorm and help organize your material before you began writing, that's AI assisted. You note it, and it generally doesn't affect your registration. But if AI generated the content itself, those portions may not be eligible for copyright protection. And content you can't copyright is content you can't prevent others from using, copying, or republishing. Your methodology, your process, that's the foundation of your business and your positioning. That needs to be your original work. If it's built on AI-generated content that you can't protect, you're building your business and your brand on ground that isn't secure. Now, one thing I tell every author, every expert, every leader I work with, do not let a publisher file the copyright registration for your book under their name. I lost over $25,000 to 2 publishers who tried to take ownership of my work. I caught it because I'm an attorney and I put a stop to it, but most people wouldn't. Make sure that you file the registration. You own the copyright and you get the certificate with your name on it. Your manuscript files need to stay in your possession. Your royalties need to come directly to you. That's not being difficult. It's not being paranoid. It's being an author who owns their intellectual property and protects what they built. I made a full video on how to copyright your book before it's even published, the exact process, the timing, and why the order matters more than most authors realize. I'll link it right here. Because here's what most people don't know. Copyright registration isn't just paperwork. It's what unlocks your ability to actually enforce everything we've been talking about. Now let me tell you what not to do. Do not upload your working manuscript into an open AI platform before your copyright is registered. When you paste proprietary material into an open platform, that content may enter the public domain and become accessible to others in ways that you didn't intend. Most platforms' terms of service allow them to use your input for training purposes, and that means that your methodology, your frameworks, the language you spent months developing could end up training a model that generates similar content for anyone who asks. There's also a practical problem. When you incorporate AI-generated suggestions into your manuscript, you lose the clean trail of what's your original work and what the tool generated. That blurred line makes it harder to file a clean copyright registration and harder to prove authorship in a dispute. If you used AI to brainstorm or organize material before you started writing, that's fine. Just disclose it honestly on the registration form. But keep a log of exactly what the AI tools touched, what you accepted, and what you rewrote. The Copyright Office wants specifics, not guesses. Bottom line, the authorship of your book has to be yours. Your methodology, your framework, your expertise, that's your intellectual property. That's your legacy. Don't hand it to a machine. Okay, let me bring this all together for you. There are 3 layers of evidence that you can create during your book writing process: your digital trail, your human witnesses, and your public record. You don't need all 3 to be perfect, but you do need all 3 to exist. Start building them today, even if you're just getting started. And if you're using AI in any part of your process, be honest about it. Disclose what the tool did, because the parts you didn't write are the parts you can't protect. Whether you're writing your first or next book, or regrouping after a publishing experience that didn't protect your rights the first time, build your documentation from the start. Your book is one of your most valuable assets. Protect it. If you're not sure where to begin, that's exactly what I walk authors through at my best-selling book bootcamp. IP protection, copyright and trademark strategy, and framework development from day one. One of our authors said it best. Ellie helped me figure out what my actual methodology is and what my business and brand are actually based on. That clarity is where it starts. The link's in the description below. Now you know how to document your authorship. But what about the ideas inside your book? Copyright protects your specific expression, but not your ideas or concepts. I made a video about what copyright law actually covers, what it doesn't, and the steps that give your intellectual property real legal protection. That's the next video to watch, and I'll link it right here. If you haven't subscribed yet, now is the time. I release new videos on protecting and profiting from your expertise every week. Remember, you were made to change the world. Now go do it. I'm Ellie Shefi, and I'll see you in the next video.